Welcome to this explainer on the foundations of legal research and methodology. Now, legal research is basically the systematic investigation of the law, and it's the absolute bedrock of the entire legal profession because it transforms raw information into actual, actionable solutions.
Okay, let's take a quick look at our agenda. We're going to cover the meaning of research, its objectives, the different classifications, the vital difference between doctrinal and empirical methods, why all of this matters, and then we'll wrap up with a comprehensive recap.
Starting right off with Section 1, the meaning of research. Before we get into the heavy legal stuff, we really need to patiently build our foundation by defining what research itself actually is. Think of it kind of like meticulously mapping an uncharted island, rather than just aimlessly wandering around hoping you stumble across fresh water, right? You need a solid plan. And this everyday idea maps perfectly to a precise, formal definition from academics Redman and Morey. They state that research is a systematized effort to gain new knowledge. I want you to focus on that word systematized. It means real research is never an accidental discovery. It's a deliberate, methodical process.
And to see how that process builds, let's look at Clifford Woody's definition, which breaks research down into a strict 5-step sequence. Let's use a really common example. Say your car won't start in the morning. Realizing it won't start, that is step 1, defining the problem. You guess the battery's probably dead. That's step 2, formulating a hypothesis. Next, you grab a meter and test the battery voltage. That's step 3, collecting and evaluating data. You see the voltage is 0, confirming the battery is the issue. That's step 4, reaching a conclusion. Finally, you swap in a new battery and the car starts right up. That is step 5, testing the conclusion. When we apply that exact rigorous logic to academics, we get Clifford Woody's rule. Research is the specific process of defining a problem, hypothesizing, collecting data, concluding, and testing.
So, if we take those general concepts and bring them into our specific field, we arrive at the exact definition of legal research. Imagine a client asks if their landlord can legally evict them over a single noise complaint. Well, you don't just guess, and you definitely don't rely on intuition. You methodically find the municipal housing statutes, you analyze previous court rulings, and you carefully apply those rules to your client's specific situation. Therefore, the formal rule is this. Legal research is the systematic finding, analysis, and application of law to answer a legal question. Again, systematic is the magic word here. In the law, method always beats intuition.
Moving right along to Section 2, the 4 objectives of research.
Now that we know what research is, what is it actually trying to do? To answer this, we rely on C.R. Cathari's academic framework, which is pretty much the gold standard. He lays out 4 distinct goals. First, imagine you're a lawyer looking into cryptocurrency regulations for the very first time. You're just trying to get familiar with a brand new topic. Cathari calls this exploratory or formulative research. Second, say you want to take an accurate snapshot of a situation, like detailing the current demographics of a specific prison. That's descriptive or diagnostic research. Third, you want to know if one thing directly causes another, like does a stricter financial penalty actually reduce corporate fraud? Testing that is explanatory or hypothesis testing research. And finally, say you're critically evaluating facts to reach a reasoned conclusion, like deciding if a brand new surveillance law violates constitutional privacy rights. That's analytical research. So remember these 4 rules from Cathari's framework: exploratory, descriptive, explanatory, and analytical.
All right, Section 3, classifications of research.
With those objectives clear, let's break down the meticulous taxonomy of how we categorize all research methodologies. It's comprehensive, but let's take it step by step. First up, by purpose. Research is either pure, meaning you're just seeking knowledge for its own sake to understand a theory, or it's applied, meaning you're trying to solve a specific real-world problem. Next, by method. Pay close attention here because this is absolutely the most crucial classification for the law: doctrinal versus non-doctrinal, which is also commonly called empirical. We are going to dive really deep into that in just a second. Moving on, we categorize by the nature of the data. Quantitative relies on hard numbers and statistics, while qualitative focuses on descriptions and underlying meanings. Next is by reasoning. It's deductive when you move from a broad general rule down to a specific case, and it's inductive when you observe specific cases to build up to a new general rule. And finally, by time dimension. Historical looks at the past, descriptive survey looks at the present, and experimental looks at controlled future outcomes.
Which brings us nicely to Section 4, doctrinal versus empirical research.
This is essentially the climax of this explainer, the massive distinction you'll use in all your advanced studies. Let's contrast them carefully side by side. Doctrinal research is your library-based, black-letter law analysis. It asks a very direct question: what is the law?
You're looking purely at statutes and judgments. Picture a scholar sitting quietly in a law library reading volumes of Supreme Court verdicts. On the flip side, non-doctrinal or empirical research is field-based and socio-legal. It asks a much broader question. How does the law actually work in practice? This involves gathering raw data through surveys, interviews, or statistical analysis. Picture that exact same scholar leaving the library to go interview police officers out on the street. So the golden rule to remember: doctrinal tells you what the law says on paper, empirical tells you what it does in the real world.
Let's look at a definitive real-world example to lock this in perfectly. If you ask, does India's Recycling of Ships Act of 2019 match Hong Kong Convention standards on paper, that is a purely doctrinal question. To answer it, you're just comparing one legal text to another legal text. But if you ask, are the shipbreaking yards in Alang actually complying with those standards day to day, that's an empirical question. You can't just read a book to answer that. You need actual site data, worker interviews, and environmental records directly from Alang. Notice the distinction. Doctrinal compares statutory text, while empirical requires actual field data. And honestly, the most robust legal research usually combines both of them.
Moving to Section 5, the importance of legal research.
Why do we put ourselves through all this rigorous methodology? Because disciplined research actively shapes the real world. Let's walk through 5 key reasons why. First, it generates new knowledge to intentionally fill gaps in existing law. Second, it drives law reform. If you want to fix legislative weaknesses, you need hard data, not just personal opinions. Third, it supports informed policymaking and judicial reasoning. Judges rely heavily on thoroughly researched material to make sound rulings. Fourth, it is the uncompromising foundation for serious legal dissertations and academic writing. You literally cannot write a proper thesis without it. And fifth, it fundamentally sharpens your critical thinking. It trains you to demand evidence instead of just accepting claims at face value.
Finally, Section 6, Comprehensive Recap.
Like any good masterclass, let's patiently and meticulously review what we've covered today so you can solidify your notes. We began with Redman and Mori defining research as a systematized effort to gain new knowledge. Then we broke down Clifford Woody's strict 5-step method: define a problem, hypothesize, collect data, conclude, and test. We locked in the rule that legal research is the systematic finding, analysis, and application of law. We covered C.R. Kathari's 4 objectives: exploratory, descriptive, explanatory, and analytical. We mapped the huge taxonomy of classifications: purpose, method, data, reasoning, and time. And most importantly, we isolated the critical distinction for legal professionals: doctrinal research, analyzing text in the library, versus empirical research, observing reality out in the field.
So as we wrap up this explainer, I want you to consider how you're going to apply these precise academic tools. If doctrinal research tells us the rules on paper and empirical research tells us the raw reality of the field, which critical gap between the two will you choose to investigate?